anywhere you like.
You know, so going back to the recipe analogy, so like if you don't have a half a teaspoon of cinnamon, does it mean like you don't bake the cake?
Yes.
No, you bake it.
A joint ARB and PZB meeting. Let's all stand for the pledge. I pledge allegiance of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, guys, thank you. Right, Elise?
Okay, Zach Brown.
Present.
Wayne Dooley.
Present.
Michael Matpick.
Present.
Mike Mullen.
Here.
Tim Watt.
Present.
Skip Whitman is not here. Shane Taylor.
Here.
Tamara Christensen. Here. Raul Loya.
Here.
Tom Reynolds. Not here. Jason Sims is not here. Lisa Jenkins, not yet here. Okay.
I'm here.
Oh, there you are. Sorry.
I'm here. Hi, everyone.
Good. All right.
Ready to share it?
Sure.
Okay.
So, great presentation today. Anybody's been through it, great. It's a refresher. Maybe some new stuff, new material? Maybe. Okay. If you haven't, it's pretty interesting. So, you folks, Wade, how are you?
Thank you very much. Good evening, everyone. My name's Wade Vose. I'm the managing partner of the Vose Law Firm in Winter Park. Our firm is the town attorney for the town of Oakland and city attorney for 7 other cities throughout the state, as well as county attorney for Okeechobee County. I myself am board certified in city, county, and local government law. And in our firm, whenever we do sunshine law and ethics presentations for city council members or county commissioners or other important boards like land use related boards, it usually falls to me to do those presentations. So what we're going to be doing today for about an hour is hitting just some very high level basics of 2 main topics and a little bit of 2 more. Sunshine law and then ethics. And on ethics, mostly going to be looking at voting conflicts. We're going to be touching very little bit also on public records and then a very little bit about quasi-judicial hearings. We're going to be doing this in about an hour, maybe a little bit more depending on questions or what have you. The materials you all have in front of you, and you'll notice it says that there, Sunshine Law, Public Records and Ethics Training for City Council members. Of course, you all are currently City Council members. What this is the PowerPoint that I use to provide the City Council members and county commissioners their 4 hours required Sunshine Law and Ethics training every year. We're going to be doing that in an hour. I'm not going to squeeze everything in. And quite frankly, I don't know that it should really have to take 4 hours, but this is the wisdom of the legislature. And these are the materials we're working from. So I'm going to be skipping around and I'm going to be hitting just some of the high points. But what I wanted to tell you all is what I find most productive in meetings like this is if you have a question that, particularly questions that really get to the heart of some issues that may be bouncing around your head, please ask the question. I tend to find that a lot of the questions relate to practical applications in our modern day, how it applies to electronics, Facebook, all manner of things like this. So we can get into a little bit of that if anybody has any questions. So with that, we're going to jump in and talk a little bit about the Sunshine Law. So important thing to keep in mind for you all, because you are not elected officials, the Sunshine Law applies both to elected boards or bodies and to appointed boards or bodies, and it applies equally to both. The general rule of the Sunshine Law is meetings of collegial bodies. And by that, I mean bodies who get together and make decisions by voting on things. Meetings of collegial bodies at which official acts are taken or public business is transacted or discussed have to be open and noticed to the public. Okay, so we break this down into a number of different elements to really analyze this. It applies to any meeting between 2 or more members of the same board. Very important. Get this question all the time. Sometimes people will say, well, okay, I'm on this board. Can I talk to so-and-so on this board about some issue? no problem under the Sunshine Law. There may be some issues under other things like decision-making in quasi-judicial matters, and we'll talk a little bit about that. But for the purpose of Sunshine Law, no problem talking between members of different boards just about your opinion on a particular thing. It governs conversations between two members of the same board. And that's when discussing matters that may foreseeably come before that board. Can you see somebody else on a board and talk about the weather? Absolutely. Can you talk about the Florida Gators? Totally. Can you talk about national politics? Yeah, you can. Can you all, in your positions as bodies that deal with land use matters and appearance or review matters and so on amongst yourselves in two or more members of that body, talk about those type of issues? I would advise you all that you can't. And I would suggest taking a broad view on it, okay? Sometimes I hear thoughts of, well, we don't have something currently agended. It might be coming in a month or two, but we don't have an agenda that's been published that says this is coming. That's not the test. It is foreseeably may come before you at some point in the future. So it's really anything in that subject matter. Another one I hear all the time is, well, we voted on that matter, we decided on that matter, so it's not going to come in front of us again. So we can now run off and talk about it amongst ourselves. That's also not going to work, because one of the best ways to know something may foreseeably come before you is it came before you in the past. There are all sorts of procedural scenarios where something or something related to it might end up back in front of you. So the general advice I would give you is matters that relate to the type of decision-making that the Planning and Zoning Board and the Appearance Review Board might make within the town of Oakland, just don't discuss those. We talk about most anything else. Now, when we talk about meetings, what are we talking about? We're talking about meetings like we're having here, or meetings when you're actually sitting making decisions on recommendations to the town commission or things like that. So regular notice meetings, everything that complies with the Sunshine Law, okay? When we say meetings, we also mean workshops. Under the Sunshine Law, there's no distinction between the word workshop or meeting or anything like that. What the word workshop really just means, is meant to convey to the public, is you're going to be discussing things in a more informal style, and you're probably not going to be making any final decisions at that meeting. But for the Sunshine Law, purposes of Sunshine Law, it's a meeting. Now, what are other types of meetings? Meetings that don't comply with the Sunshine Law, but are still meetings that could violate the Sunshine Law if you do it. We're talking about telephone calls and text messages between each other, emails or written correspondence between each other, or informal discussions or deliberations. This last one, informal discussions. All the time I get, when you go read the actual wording of the statute, people say, well, we're not making any final decisions on it. We don't have a quorum there making decisions. Just two of us talking, but we're just talking informally about it. Well, that's probably a reasonable reading of the statutory language itself, but that is not how the Florida Supreme Court has interpreted it since the 1970s, okay? Both the Sunshine Law and the Public Records Act both start from the Sunshine Amendment. The Florida Constitution came in the late 60s. And the Florida Supreme Court has been very particular in clamping down, in not allowing for what they call any evasive devices, any ways to get around it. So they overread it. They overread it very broadly, okay? So even if you're not getting together and making final decisions, down at the bar or wherever, you're just chatting about a thing, that's going to be a violation of the Sunshine Law if you're talking about a matter that may foreseeably come before you. So the best advice is simply talk about anything else, but don't talk about those subjects. So how do we comply with the Sunshine Law? A lot of this, for your benefit when we do it right, is all handled by staff, okay? So to comply with the Sunshine Law, we need to meet three basic requirements. First, meetings and public boards or commissions have to be open to the public. All right, we're going to drill down what each of these things means with some particulars. But second, reasonable notice in the meetings must be given. And third, minutes of the meetings must be taken, promptly recorded, and open to public inspection. You'll notice that 2 and 3, that is all 100% handled by staff The first one is mostly handled by staff. So when you just confine your discussions about matters that may foreseeably come before you to matters that are, to meetings that are arranged by staff, you're good to go. So let's break down what each of those things mean here real quick. So meetings must be open to the public. That means, like here tonight, if anybody from the public, this is an open notice public meeting. Anybody from the public wanted to come in here and listen to everything going on in here, they have an absolute right to do it. What that also means for a meeting to be open to the public is if we ever, I haven't heard in recent years it happening in Oakland, but happens other places Orange County sometimes. If members of the public were to come in here with audio tape device or videotape device, on their phone or video camera or whatever, the Sunshine Law allows members of the public to non-disruptively video or audio record a public meeting. So if we ever have anybody show up to set up, so long as they're not being disruptive, they're allowed to do that. It's part of being open to the public. It also means you have to hold it in a place that's of sufficient size and capacity. Now, we had to deal with this a lot during COVID, all right? Because what capacity is for a room has changed. So if we reasonably knew that we were going to have a meeting, where we were going to get 100 people out, right? Even before COVID, it would have been incumbent on staff really to do our best. And, all the law can do is ask us to do our best. Do our best to have a public facility available, arrange for a public facility where we can accommodate those people or get creative. Some creativity we've had since before COVID or afterwards, provide opportunities for people to cycle in and out, to be able to listen online the whole time so they can both listen and then participate to offer any public comment. We'll get to that in a minute. But in any event, what it prohibits is an unfortunate practice we saw even before COVID sometimes, where we knew, not here, obviously, but some places where we knew 200 people were going to come out and you hold it in a room a quarter this size on purpose. That is not cool under the Sunshine Law. Reasonable notice must be given. So everybody asks me all the time, well, isn't there a 48-hour rule or a 7-day rule or a 14-day rule? All that's not so. There are particular statutory requirements for particular type of ordinances or other decisions you all make, all handled by staff for advertising in the newspaper or anything like this. But that's because of the exact nature of that decision, a rezoning, an ordinance adoption, what have you, comp plan change. To comply with the Sunshine Law, all that's required is reasonable notice the meeting has to be given. Reasonable notice doesn't necessarily mean publishing in the newspaper. Most people don't read the newspaper anymore. It means publishing it in a reasonable manner and a reasonable time before it. And that can mean posting it at town hall, it can mean posting it on the website. It can be a combination of those things. It can be mailing out notices, things like this. And also for the town commission in emergency circumstances, 24 hours might be very reasonable notice if a hurricane's coming. It all depends on the circumstances. Finally, minutes have to be taken, promptly recorded, open to public inspection. Staff handles that requirement. But of course, as you can imagine, you can see when you listen to these things, how just a telephone call impromptu between two or more members, of one of the boards, talking about an issue that may foreseeably come before you, can't tick these 3 boxes. That's why it violates the law. So now we're going to skip a lot of stuff that doesn't directly apply to you guys. Oh, one important thing for you all to know. There are exceptions to the Sunshine Law. They're incredibly limited. Really none would ever apply to your boards. And unfortunately, there is not a, this is really embarrassing, we wish you didn't have to talk about it in public, exception to the Sunshine Law. Those exceptions to the Sunshine Law can only be passed by the legislature, and it takes a 2/3 vote of each house to even pass it. So extremely difficult to get an exemption. Pretty much none of them apply to land use matters. Another very important point. So we were talking about 2 or more members of the same board talking with each other about a matter. Well, there's a principle in the law and applies in the sunshine law. You can't do indirectly what you're not allowed to do directly. And application of this in this instance is the idea that you can't use another person, two or more members of a collegial body, you can't use a third party, a third person, whether that's a staff or just a member of the public or an applicant or a lobbyist or anything like this to act as a liaison or what we call a conduit between two or more members of the same board. So you can't use them to pass information one to the other. So for example, a board member can't go up to a person and say, hey, go over there and tell Joey, I'll vote for him for chair if he votes for you for vice chair. Or, hey, if you tell him if he fires up the motion, I'll second it. Okay? These are unfortunately exceedingly common things that people think to try to do, and they will land you in a world of trouble. We'll talk about the trouble in a minute. But so that's a really obvious glaring example. Here are some other examples that I would recommend you strongly stay away from. If you have somebody approach you to start telling you, hey, I've got 2 board members already lined up, you'll be my third vote, can I count on your vote? I'm going to give you the advice that you should stay very far away from that conversation. And once you hear that being teed up, you ought to call a timeout immediately and say, hey, I don't want to hear who you got votes from. I don't want to hear any of that stuff. Somebody wants to talk to you about the merits of some project. We'll talk about disclosing ex parte communications on quasi-judicial matters, all of that. But somebody wants to tell you about how many votes they got or anything like that, I suggest you very strongly don't participate in that conversation and say, hey, sorry, no offense, but I don't want to have anything to do with that conversation. And here's why. There, you didn't initiate a violation of the Sunshine Law, right? You didn't go asking, hey, who else is on board or anything like this. But the second you start actively participating in that conversation, it's quacking a whole lot like a duck. It's looking a whole lot like you're participating in passing information back and forth. And as I'll point out later, it's all fun and games with this stuff until you get that call from the state attorney's office. And that's going to ruin your whole year. Okay. Even if it all pans out and washes out. And I don't mean to scare you, but I do mean to scare you a little bit. I mean to scare you into saying this is not worth it to fool around with this stuff. Let's just not talk about it. Easy peasy. So we talked in my haste to talk about a lot of things in 1 hour. We talked about some of these things: adequate size, located to open to the public for meetings, and so on. Big thing I want to talk to you all about is right to public comment. So we talked about those 3 elements for Sunshine Law: open to the public, notice must be given, minutes taken, and promptly recorded. Those were the elements to comply with the Sunshine Law for decades. And then in 2013, the Florida legislature, in their infinite wisdom, decided to add a 4th requirement. It's a little bit different in how it works, but it's a right to public comment. Why the legislature felt the need to add this, I don't know, because every local government I've ever represented has allowed public comment on pretty much everything. And with regard to quasi-judicial matters, as we'll discuss, members of the public generally have a right to public comment on those as a matter of substantive law, but they added it. So what does it mean? It's actually really narrow what it actually requires. The statute requires that members of the public shall be given a reasonable opportunity to be heard on a proposition before a board or commission. The opportunity to be heard does not have to occur at the same meeting where that board is taking final action on that, so long as they were given the right to have that public comment at some reasonable time period before that decision. So what does this technically mean? If you were making a decision that, again, wasn't a quasi-judicial matter, I keep mentioning this because you all make a lot of quasi-judicial decisions on both of your boards. But if it's a legislative decision, just a decision on broad policy. You've got in the planning and zoning board, you've got changes to the comprehensive plan or changes to the land development regulations coming before you, broad policy that would affect the whole town, and so on. Theoretically, you could, if you're having 3 or 4 meetings because you're working through a lot of stuff on a particular proposition before you, a piece of work before you, you could say, yeah, we'll have public comment on this at the 3rd of 4 meetings and not have public comment on any other. I'm going to recommend to you that you not do that. I'm letting you know what the statutory minimum is, and I'm going to tell you what my advice is. My advice is let people say their piece, because there's no better way to get people disgruntled than to stop them from talking. Okay? Now, under the statute, it's actually helpful in this way. It made crystal clear that boards can provide for rules for managing that public comment. They can have time limits, okay? And they can have procedures where they can, the chair can invite folks to, if 25 people are all there to say the same thing, can invite them. You can't force them, all right? But you can invite them to say, hey, look, it would be a lot more effective for you all if you picked 1 person or 2 people to come up. We'll give you extra time. Like, you know, normally give 4 minutes, we'll give you 6 minutes. Come up and say the piece for your 25 people there. If you want to, can't force you to, but if you want to. And then that gives you the opportunity to keep it more succinct and gives them the opportunity to not have to get up and say the same thing over and over again and so on. So it's a useful thing in this otherwise unnecessary statute to put some of those ideas out there, that those are things that can be done. You can also, of course, if you have folks, you can maintain decorum. The mere fact they have a right to public comment does not mean they get to stand up and start without any basis at all, you know, saying somebody's corrupt or a child molester or what. I've had to deal with this when people just go wildly off the rails, not having anything to do with the matter at hand. Public comment should generally be directed to the matter at hand, or they get physically violent or cursing. You can stop people from cursing, and if they continue to do so, you can, the chair can find them out of order and can ask them to stop. So there are exceptions to the requirement as well, some pretty obvious ones. For ministerial matters, approval of minutes, things like this, you don't have to allow public comment for things like that. For quasi-judicial matters, the statute says that you handle matters that in the way you have to for quasi-judicial matters. Basically says it doesn't apply in those instances. Now, why are we worried about all these rules? First reason is, of course, we want to follow the law, and that's a good idea and so on. But of course, the law, the Sunshine Law, comes with penalties as well. A knowing violation of the Sunshine Law is a second-degree misdemeanor. And again, like I said, that all said, oh, a second-degree misdemeanor, that's nothing, whatever. That's all fun and games to get that call from assistant state attorney or an investigator with the state attorney's office. And they start saying, well, an accusation has been made and we're investigating it. And that is not a call you ever want to have. Okay. And we, as you all may know, if you follow the news here in Orange County or other surrounding counties, it is, we wish it was less often, but it happens. Fortunately, the most recent example I can think of is not here. It's down in Indian River County in Sebastian. There are multiple, this is back early in COVID, okay? Multiple city commissioners there in the city of Sebastian. They weren't keen on what the city manager had ordered right at the beginning of COVID about locking some things down or what have you. So they decided on their own, without noticing it, without it being open to the public, they locked the door, they physically locked the doors and didn't stream it, didn't do anything. ran into City Hall, locked the doors behind them, 3 of them, and purported to vote to remove their mayor, fire their city manager, and fire their city attorney. This has not ended well for them. It did not accomplish removing the mayor or firing the city manager or firing the city attorney, but it did accomplish them getting charged with a crime, with multiple crimes, actually violating the Sunshine Law. This is a very extreme example, all right? But there have, of course, been others over time. Even an unintentional violation, this is really important, all right? Unintentional violation, which means you can say, look, it never even occurred to me. I didn't knowingly do it because the statute requires for it to be criminal that it be knowingly. Didn't know I was doing it or anything like that, still against the law. And you can get a non-criminal violation infraction up to $500. And guess what? It's not the money that's going to hurt doing that. It's not a fun thing to have any of that come around. Now, in addition to that, not just for you all personally, there are negative effects for the town if there's a violation of Sunshine Law with relation to some decision that's going on, okay, some important decision. So the Sunshine Law provides that no resolution, rule, regulation, or formal action shall be considered binding except as taken or made in an open public meeting. So what does this mean? Again, remember I told you that the Florida Supreme Court has been extremely draconian on this. And they've said that the law should be construed to frustrate all evasive devices. So what that means is if there's a Sunshine Law violation somewhere in the chain of decision-making for making some decision, somebody who doesn't like that decision can come in, sue, try to have it found that a Sunshine Law violation occurred somewhere in the chain of the decision-making and have that decision found void ab initio. That's Latin for void from the beginning, okay? So it wipes it out. Now, there are some lawyerly ways we can fix this. If there was an unintentional violation, you can go back and do some things to show that you follow the full process otherwise. But what it does is on any decision that you're looking to make, it potentially puts that decision in peril. And I'll tell you, more often than not, with these and with anything, with public records violations, with ethics violations we talk about in a minute here, it's likely never going to be about the unimportant stuff. It's going to be about something where somebody has an interest and somebody's going to have an axe to grind. Are you going to have an axe to grind, with somebody for a decision that was made, with somebody for making a decision, or about the decision that was made? And when you couple money and interest with giving somebody an easy ability to accuse you of a crime, that's just setting yourself up for failure. So we recommend staying far away. So those are the basics of the Sunshine Law. It normally takes an hour for me to do that, and I did it in a half. So do you all have any questions about the Sunshine Law?
What if somebody has the axe to grind with you and they falsely accuse you of doing a Sunshine Law, and they go through the whole investigation, the state contacts you? Who represents you in that? Is it you, the city attorney?
Not on the criminal matter, no. And when it comes to, yeah, you get an accusation against you.
Right, I'm totally not guilty.
Sure, of course,
Yeah.
right. Yeah, you get a completely 100% unfounded accusation against you, right? The city attorney's office, you'll have all our sympathies all day long, but the city attorney's office doesn't represent you. It would be, if you wanted one, a private criminal attorney. Okay. And it wouldn't necessarily be paid for by the town. So the best way that I can tell you to stay far, far away from that is to stay really clean on it, so that with these things, just so you know, state attorney's office, at least in the Ninth Circuit here, never charges on these things before having an investigator look at it and usually having an opportunity to talk with you. All right. Now that can be dangerous in its own circumstances and so on. But in any event, if you can show, look, I I stay far away from that stuff. I want nothing to do with doing any of that stuff and so on. It gives a different look than, hey, it was okay what I said. You see what I'm saying? If you're trying to defend some particular thing that was close to the line, that's a different game than, no, I never talked to him. So unfortunately, someone could accuse any of us in this room of any crime we can think of.
Correct.
At any time.
That's more what I'm saying.
Yeah, I mean,
They don't like the decision, they're gonna go and say, oh, I'll get you.
That's life. Yeah, that's life in society, I suppose. But yeah, I will tell you 100% just accusing it when they don't even have something to run with. I haven't seen very much of that in practice. But never know. You never know.
I have a question.
Yes, sir.
When you have the ability to, for the public or somebody to come in there to your meeting and disrupt, not in a disruptive way, but say videotape an entire meeting or a particular item, can that be utilized as a verbatim record?
That is a great question. I don't think the case law likes, I think it can be used to create a verbatim record. So what Jay's talking about here, this is related matter. We might as well talk about it now. Let's talk about quasi.
We're going to talk about it later. That's fine too.
No, this is as good a time as any because I mentioned quasi judicial a number of times here. By the way, that's not in this PowerPoint here because talking about quasi judicial matters is not in the 4-hour ethics stuff that you teach, but it's frankly more important for you guys than for a town commission. They make quasi judicial decisions as well, but it's a less of a proportion of what it is. Okay. So what Jay's talking about is one of the things at issue commonly in quasi judicial matters. If somebody wanted to appeal in the circuit court, a decision that was made, a final decision that was made by one of your boards, one of the statutory requirements, they have to have a verbatim record of that. Why? Because court needs to be able to look back and they're not going to listen to an audio tape to understand what went on. They want to read a transcript. So Jay, I think if somebody did videotape it and then gave it to a court reporter, I believe that would suffice, so long as they can demonstrate it's a true and accurate audio tape of it.
So that's like when they brought in those transcribers, right, for that property that we were
Yeah,
dealing with.
did they have a court reporter here?
Yes.
Yeah, that is, and by the way, that's usually one of your signs when we're going to turn up the juice a little bit and be slightly more formal in our quasi judicial decisions, when you've got applicants or anybody else coming in with a court report. All right. That doesn't mean you got to go all nuts. Just means somebody's paying close enough attention that they are thinking, look, if this goes completely off the rails, they might feel they have to go to court.
They had somebody here representing them, like a legal.
Sure. Their attorney, then the attorney brought their court reporter and it took.
And that was contentious.
That was a development.
There was cursing, there was
Oh, yeah.
almost a physical altercation. Yeah.
It wasn't good.
So while we're on kind of that topic, let's talk really quickly about just the bare bone basics of the concept of quasi judicial decision making. Okay. What we're talking about is when you're making decisions that have to do with the rights of, say, a single piece of property. Okay. So particular property owners, that's the blanket conceptual idea. When you're talking about changes to the land development regulations that will apply to the whole town or part of the town, or whatever, or the comprehensive plans or things like this, or some other big plans, generally not quasi judicial. Those are legislative. And basically you just make your decisions based on your best judgment of what's good for the town. In a quasi judicial decision making, your job is to make decisions. It's called quasi judicial because it's quasi like a judge. Okay. Don't get to wear a robe or anything like this, but you're supposed to be making it a decision the way a judge does. And that is based on the evidence that's presented before you and the law. All right. So what's the evidence? The evidence generally is going to be what we call the competent substantial evidence that's presented at the meeting. All right. Competent substantial evidence could be a report and recommendation from planning staff, from Jay. okay? Competent substantial evidence could also be professional reports and so on from the applicant, all right, providing information. Other experts like engineers, either for the town or for the applicant, or a mixture of both. What is generally not competent substantial evidence of most anything that relates to the law that's going to apply, the land development code and the comprehensive plan and so on, is going to be members of the public coming in saying, I don't want this. And I hate to say it, but that is the law. They have a right to tell you that, by the way. Okay, they have a right to get up and tell you they don't want it. They can tell you why, okay? But ultimately, your decision has to be based on the competent substantial evidence before you. Now, there might be times when members of the public can offer lay testimony that is evidence-based, okay? Not their opinion conclusions that if you allow this thing to go in here, then traffic's going to increase. A lay person is not competent to give you that professional opinion. A professional traffic engineer might be, okay? And the professional traffic engineer for the applicant who says, no, it won't give any increase, or the towns that says it will be a great increase, those might both be competent substantial evidence. Then you get to sort through it and make the decision, all right? So, and then I mentioned the other part, make decisions based on the facts, the evidence before you, and the law. The law is going to be applying the land development regulations and the comprehensive plan as for, a particular source of law. Now, that relates to another issue in quasi-judicial matters, the disclosure of ex parte communications, all right? Why do we do this when we're talking about quasi-judicial matters? We ask anybody to have any disclosures they need to make about any quasi-judicial matter that may be coming before them in that meeting. And those generally are conversations with really anybody about an application that's before you. Could be the developer. Well, sometimes I will tell you, that's asking for trouble, but it is not illegal, but it must be disclosed, okay? Conversations with town staff. I mean, you don't need to dig down into, every single word anybody said in any of these things, but you disclose it in the general substance of what it is. Members of the public, if they stop you in the post office to tell you about whatever, and then site visits. Site visits, a little bit different, but it's a little bit the same. You went out and observed with your own eyes, something X or Y. Why do we disclose site visits? Because it's some piece of evidence that may bear on your thinking, but it otherwise wasn't disclosed in that room unless you disclose it. So you want to disclose site visits as well if you engage in a site.
Are you saying site visits should not be made or should be made?
No, I'm not discouraging site visits. I'm saying they need to be disclosed.
Would driving past a piece of property be considered a site visit if you on your way to some other location? I mean, if you just happen to pass it, or?
Yeah, and again, I'm not telling you no. I would just say if you want to be really clean on quasi-judicial disclosures or on ex parte disclosures, if you drive by a site, 3 times a week, just say, drive by the site 3 times a week. I see it as I drive by. That's all you need to say. But that, and by the way, I'm not telling you missing one of these things means the decision you make is illegal. It's going to get overturned, anything like this. That's not the case. And it's, by the way, it's not illegal or criminal. Okay. Like we were talking about the sunshine law, violating the sunshine law or anything like this, a failure to disclose some piece or another of quasi or of ex parte communication is not in itself a crime or anything else the same way that we talk about the sunshine law. What it does do though is potentially, if down the line somebody wanted to challenge it and the challenge was adverse to it and that failing to be disclosed so they could try to pound into a court, hey, he didn't disclose this. This is the real reason why he made it. You should overturn this decision because of this. So failing to disclose is really only potentially handing somebody else a tool to overturn the good decision you made. So that's why we do our best to do it right the first time. So it's not coming back around the bend over.
Okay, so there's no cons about if you see you get your meeting packet before the meeting and you're talking about a piece of property that's located on Highway 50, you're like, I'm just gonna take a ride out there and just get an idea what it looks like, because we're gonna be discussing it.
Yep.
So at the beginning of the meeting, you would say, hey, look, I drove by this.
Yep. And that's all it is. And there's nothing, in fact, statute right on point that says there's no, particularly when you disclose it, there's no negative connotation or presumption that it affected your thinking. But that's why you disclose it. So it's out in the open. There's no problem.
So when I was in Oregon, we took a development to a city council, and one of the counselors said, I talked to all the neighbors and I know all their basements flood, and building this property is going to cause excess flooding of those basements. So he did his ex parte disclosure, but he wouldn't recuse himself, which we were like, he's already has preconceived notions of how he's going to vote, which surely he voted that way.
We're going to talk about voting conflicts and recusal in quasi judicial matters in just a minute.
Okay.
But I want to take, this is a good example though, on this other thing, on the other matter about lay testimony versus expert testimony in contexts like this. Talking to five members of the public around a piece of property, and all five of those members of the public telling, hey, if you build this then our basements are going to flood. Unless one or more of them happens to be a structural civil engineer, they don't know that, or they can't know that for the purposes of giving evidence or expert testimony. You understand what I'm saying? So it's the perception or people's belief that they understand what will be the demonstrable consequences of the thing versus they're simply expressing, I don't want it there. You don't want it there. So with that, if there aren't any other questions, I'm going to hit very quickly the public records law. I'm not sure how much I'm going to use of the Public Records Act because it gets in the weeds, but I'll use this. So basically, what the Public Records Act provides for is a right of access to records of state and local governments, as well as, get in the weeds even more, private entities that are acting on behalf of government. But so first question is, if you have a right of access to public records, what is a public record? Statute says all documents, papers, letters, maps, books, tapes, photographs, films, sound recordings, data processing software. This is the 1970s legislature trying to imagine the future, okay? Or other material, regardless of the physical form, characteristics, or means of transmission, made or received pursuant to law or ordinance, or in connection with the transaction of official business by an agency, all right? So,
That means
for your purposes,
right?
What's that?
Everything on your phone, basically.
We're going to talk about the infection theory of public records. I hear it very commonly, and it is, you'll be happy to hear, not the case. Okay, good. Okay. So the Florida Supreme Court has interpreted that definition for public records to encompass all materials, and this is important, it's got to hit these elements, made or received by an agency in connection with official business that are used to perpetuate, communicate, or formalize knowledge. So let's hit this right off the bat, emails. So let's say, because emails is one question I get all the time. So let's say in your private email address, you have some project that's going to come up before one of your boards, and you get an email from a member of the public saying, hey, look, I'm against this project, or this project's best thing since sliced bread. That email to you relating to your work on the appearance review board or the planning and zoning board is a public record. Okay. The mere fact that you received into your email inbox a public record does not turn the rest of the emails in your inbox into public records or anything else in your phone into public records. Very important. I hear it all the time from folks. They think, if I get any public records, it infects my entire email box and all this stuff. It is not the case at all. All right. Now, what it does make incumbent upon you all, if you receive any public records, if you receive any emails in your inbox that would be categorized as public record, you, unless we figure out a way to fix it, have an obligation to retain that public record and make it available for public inspection. But I think we have an easy solution that we're about to hear.
Get all those over to me.
Exactly.
And if you ever get a public record request, those all go to me. I handle all those. But if you get an email like that, something like a text message, take a picture of it, get it over to me. I'll make sure that it gets archived so we can have it available.
And this is about as much as I think we need to dive into the weeds on it. Your obligation to maintain all that stuff can all be sent right over to the clerk's office, okay? So the easiest thing to do, what I strongly recommend in the strongest terms, is you get one of those emails, easy peasy, forward it onto the clerk's office. You get a text for some reason, take a screenshot of it, email it to the clerk's office. Now you can put it right out of your pretty head. You do not have to worry about it again because the clerk's office will handle it. And yes, if you ever by chance, somebody makes a public records request of you, the chances of this have reduced substantially because we used to have a lot of public records request abuse in Florida. Folks who come in, troop in to make public records requests to kind of set up the government to violate the public records law, and then they'd sue and get lots of money, their attorney's fees, all this great stuff. Legislature did some innovations last couple of years that really clamped down on a lot of that, generally a good thing. But if you ever get a public records request, send it right over to our custodian of records, who's the clerk. Clerk will handle it. So does anybody have any questions on the Public Records Act? All right, then I'm going to skip way ahead. Oh, yeah, and again, you do that stuff, you'll never have to worry about it, but violation of the Public Records Act is which is even worse, and all sorts of bad things happen. So, ethics. We are going to be, there's a lot of things we could otherwise talk about, but most of it's probably never going to come up, so we're just going to talk about the thing that will potentially come up, and that's voting conflicts, okay? And then the related matter of recusing yourself if you have a voting conflict or for other reasons. So there is a particular statute that governs this, 1123143. And who does the voting conflict statute apply to? It applies to public officers, applies to you all. Anybody on an elected or appointed board, including advisory bodies. So it applies to anybody on a collegiate board, basically the same thing as if anybody that the Sunshine Law applies to, okay? Now, what is a voting conflict? This is how it breaks down, and it gets a little complicated, and the real answer, the whole reason for even saying this out loud to you all is to kind of put little ticklers in your head to issue spot, as attorneys call it. If you start seeing anything that looks like this, pick up the phone and call our office. Pick up the phone and call me, call Nancy, call Becky, pick up the phone and call one of the attorneys with our office, and we'll talk through the issue with you, because what we don't want for our town commission, what we don't want on any of our decision-making bodies is somebody having an issue with regard to voting conflicts if we can just talk through it and analyze it. So what it requires is a local elected or appointed officer may not vote on two types of things. First, any matter, or any measure, pardon me, which would inure to his or her special private gain or loss. Pretty obvious. We're going to break down what each of those words mean. We got ourselves, right? Or any matter or any measure which a public officer knows would inure to the special private gain or loss of 4 categories of folks. A principal by whom you're retained, a parent organization or a subsidiary of a principal by whom you're retained. All that really means is basically if you're retained by somebody, we'll talk about what retained means. You can't sidestep it or get around it by having a company in the middle. It's turtles all the way down, really. A relative that knows you know it'll inure to the special private gain or loss of a relative. And we'll talk about the definition of a relative. And a business associate. We'll talk about that definition. So who's a principal? It's really talking about 3 types of folks. All right. An employer. All right. So if you had somebody, an applicant coming before you, and the decision you would be making would inure to the special private gain or loss of your employer, even if your job in employment has nothing to do with lobbying for land use matters or anything like this, all right? If it would be to your employer's special private gain or loss, you're going to have a voting conflict, and we'll see how we deal with that. Another type of principal is a client, all right? So a client in a legal practice, an accounting practice, certain types of insurance practice, depending on the type of insurance, gets a little hazy there, or other professional practice when you're in some sort of fiduciary or client relationship like that. And then finally, a corporation for which you serve as a compensated director. I'll tell you the most common example of this, all right, of the exception to this, why compensated is important there. Had a number of different times over the years where a church, all right, is going to be having a zoning application come through or some other application. And person on the decision-making board is on the board of the church. All right. For the purposes of complying with the conflict of interest law, the voting conflicts law, there is actually not a problem. Now we'll talk about whether or not you should still recuse yourself in a second. All right. But if you're not a compensated director, and that means getting paid money, not just you get your expenses reimbursed if you had to travel somewhere, but you're getting paid $500 a month or $20,000 a month to be on some corporate board, then they're your principal. But if you happen to be on it on a nonprofit capacity, you're not getting paid anything, you actually don't have a voting conflict. Again, it can get, like I said, it can get in the weeds. So this is why when you issue spot this, it looks a little bit like this. It's quacking like a duck a little bit. We want to talk about it and walk through every single element to make sure you're in the right place. Now, relative. We're not going to be getting into the weeds of all the different ethics statutes that apply. Most of them would not really come up for you guys, but in all the different ethics statutes in chapter 112, there's a different definition of relative for each one. Some are very narrow, some are extremely broad, okay? And it varies based on the circumstances. For the voting conflicts law, it's really narrow. It's father, mother, son, daughter, husband, wife, brother, sister, father-in-law, mother-in-law, son-in-law, or daughter-in-law. It may seem like a lot, but notice who's missing. Uncle,
His nephews.
niece, nephew,
Yeah.
cousin. Exactly. That comes up a lot. That comes up a lot in small towns. I can tell you that. Oh my goodness, cousins. But so this is actually pretty narrow. All right. So, and it doesn't kind of chain on. It's not like your sister's father-in-law's son, or anything like that. It's just this list right here. All right. Now, again, we'll get to whether or not for various reasons you might nevertheless recuse yourself in a second. But the question here is whether or not you have a voting conflict where you'd be absolutely 100% required to recuse yourself, and you might get in trouble with the Commission on Ethics if you don't. Okay. Final one, business associate. So this one's a little amorphous, but you know it when you see it. It's basically a person or entity who's carrying on a business enterprise with the public officer, regardless of the form of the business. 2 key questions. Are they engaging in a common commercial or entrepreneurial pursuit? And 2, is this a current ongoing business relationship? I'll be very, very clear on this. The business relationship that you have ongoing does not have anything to do with the project that's before you. Okay? So I'll give you an example. Because we're in Orange County, I won't use names. When I'm traveling far afield in the state, I get to get a little bit more specific, but I don't want to throw anybody under the bus. But we had an instance years ago on the Orange County Commission where we had a commissioner who was a commissioner. He also happened to be a real estate developer. And we've had a number of real estate developers on the Orange County Commission, so they're hiding in company there. But an applicant come before the county commission on something that this commissioner had no involvement in, all right? Nothing to do with this project right here. But this commissioner in a different county owned a piece of land that they were holding to develop with that applicant, all right? Never disclosed, and no conflict was declared and didn't recuse themselves. Later, somebody figured this out and brought it to the Commission on Ethics. And that commissioner ended up entering into a consent decree with the Commission on Ethics because he said, oh, I never even thought about it. Because you don't think about it. So anybody that you're in an ongoing business relationship with, doesn't have to be about the project that's in front of you. That person you've got to evaluate very strongly to see whether or not they're a business associate for the purposes of the voting conflict law. Now, what is special private gain or loss we're talking about? Voting conflicts law doesn't apply to all situations where it might result in gain or loss to the official. The gain or loss has to be special. All right. Now, what do we mean by special? Well, I'll give you a broad concept here and we'll go into the particulars. First off, it requires an economic benefit that will endure to one of these votes. Used to be in the really old opinions before the legislature clarified it. You had folks all the time getting ethics opinions. Oh, well, it's to their political benefit to decide this or decide that. Guess what? Every decision is to the political benefit or detriment of the person making the decision, however you want to characterize it. That's not what they're talking about. They're talking about money or value of land, making money, economic benefit. The other general concept is this. Every decision you all make, and you all are, everybody's a town resident, right? Mm-hmm. Yeah. Every decision you all make, and even if, by the way, even on boards where you weren't a town resident, you could also be like a town business owner. Every decision the boards make affects everybody in the town to some degree or another. All right. So that means everybody's got a conflict now. That's why it's got to be special. All right. And we evaluate it based on a number of criteria. What's the size of the affected class of the decision that you're making? What's the relative benefit or harm when compared to other members of that affected class? Is the gain or loss remote or speculative? Is it related to that? Is it merely a preliminary or procedural measure? So size of the affected class. Yeah, here we go. Size of the affected class. If you're doing a rezoning on one piece of property, one person owns it, the primary person you're going to be looking at is the owner of that property for special private gain or loss, because you're going to upzone it, downzone it. You're going to do something to it. It's going to have some economic effect. All right. We might get into the weeds a little bit more if it was going to be the rezoning, if it was the immediate neighbor and it was going to somehow adversely affect them. Maybe we'd look a little bit at that, but the primary folks we're going to look at is the property being rezoned. Making a decision that's only going to affect 5 properties in the town. Now we're getting a little bit more ambiguous. We've got to look hard. If you're making a change to the land development regulations, that's going to affect all the property in the town or half of it or what have you. Probably really big affected class, probably not going to be a voting conflict. So like it says, small the class, greater chance of special gain and vice versa. Is it remote or speculative? If chains of logic saying, well, you know, if we make this change, then down the road, these two other things could happen, and some subsequent thing could also happen, and this thing could also happen. Therefore, it's a voting conflict. These get very difficult. You've got to look through and see how much you're kind of chaining your logic together to try to say somebody's getting some benefit. An upzoning or taking a piece of raw land and getting a development approval to build an apartment building on it and so on, that's to the economic gain of whoever, is applying. Very easy. And then preliminary procedural, this is to get rid of pedantic arguments like, oh, well, you voted to approve the agenda that the item was being held on. If you didn't approve the agenda, then they couldn't have considered it and therefore whatever. Or you voted to approve the minutes after it happened. If you didn't approve the minutes, it would have never been written down that it was approved. This is nonsense. This is to get rid of these things. Or it's talking about making decisions on the substance of the matter. So let's say you've gone through the analysis and you determine that you have a voting conflict. What are you required to do? You're required as appointed officials to actually do 4 things. There are 3 things listed there and then 1 additional one. So first, you're required to abstain from voting on that matter. You have to disclose the conflict orally in the meeting out loud prior to the vote. And you have to file a Form B within 15 days. And the town clerk and staff will help you sort all that out. And basically on that form, you just disclose what the conflict is and sign it, and you're good to go. In addition, for appointed local officers, that'd be all of you, you have to publicly disclose the conflict before participating in discussion of the matter. Now, think through the converse of this for a second. What this actually means, technically under the statute, is elected officials are allowed to wait until the very end of the discussion to disclose their conflict. They could sit there and say, this is the best thing since sliced bread. We need to vote for this or else the town will fail. It will make the town the best thing in the world, and go on all this time and get everybody hyped up. And then right at the end say, oh, by the way, this is going to make $5 million for my brother, so I'm going to be abstaining. I generally recommend to elected officials that's a bad idea. If you're going to participate in discussion, which you're allowed to do in any circumstance, disclose it first. It's just a really bad look. You all are required to, so disclose it prior to discussing. Now, I would leave to your good judgment whether, if you have a conflict, whether you would participate in discussing. There are times when you will have what is a mere technical conflict, okay? Where it's just technically it's a conflict, but you truly have no interest and you couldn't care one way or the other, this person who's technically a conflict, whether they win or lose or whatever. You might, in your judgment, say as much after disclosing it and then go on and say what you want. But if it's going to make your brother $5 million, probably a hot idea to say it's going to make my brother a lot of money and I'm staying out. Just a piece of general advice for maintaining the appearances of propriety. Now, little quirks that, does anybody work for a local government? Anybody work for a government in your regular job? No. Okay. Let me mention this in the, what's that?
The last thing was the form.
Yeah, I mentioned Form AB. Yeah, you file the form. Yeah, you file the form with the clerk's office, and then they actually take that form and they attach it to the minutes.
And if you look at the agenda and you know there's going to be a reason you recuse, let me know and I can bring the form to the meeting and we can just do it right there.
I go back. Lost my stuff. Sorry. Not liking. I apologize, guys. Actually, that's the slide I need to get to, so we're good. So along with conflicts of interest, we got the flip side, okay? Yeah, here we go. All right, yeah. We have the flip side, and that is under Florida law, the requirement to vote, all right? Under Florida law, you can't vote present. If you were present for, if you were physically at a meeting or by Zoom in a hybrid meeting, as we might do, if you're in a meeting, you have to vote yay or nay on anything that comes before you. You don't get to cash out and not take a hard vote unless, as the statute says, except when there is or appears to be. Notice that lawyerly weasel words there. There is or appears to be a possible, other weasel words there, possible conflict of interest. All right, so what does this mean? First off, on just say any sort of matter. It's not technically, if we get really rigorous, not technically a conflict, but it looks a whole lot like a conflict. All right, it's your first cousin who you grew up with and he's like a brother and he's going to make $5 million on the deal, right? This statute gives you the wiggle room to say, look, hyper technically, it doesn't satisfy all the elements of this conflict, but it's really close and I'm going to abstain. You still do all the same things to abstain and so on, you document it. And because that example very easily falls into appears to be a possible conflict of interest. All right. In addition, and this is important for you guys, on quasi judicial matters, if you've got a quasi judicial proceeding, you have an additional option to abstain, to not vote. And that is if the abstention is, and I'm quoting from the statute here, if the abstention is to assure a fair proceeding free from potential bias or prejudice. This is, what's that? No. So keep in mind that it's not an obligation to abstain. So if somebody say, oh, you're biased, somebody said, just because somebody says you're biased or prejudiced does not mean just somebody accused you of it, means you have an obligation to abstain or anything like this. It is an option that's available to you if you, in your own mind, in your own judgment, think, I'm so against this. I can't, my mind cannot be changed. Like a judge recusing themselves. Okay. My mind cannot be changed on this. This is just where I am. I'm a human being. It's all I can do. I can't be fair on this particular matter. You're allowed to abstain. But let me tell you what you're saying when you say that. What you're effectively saying is, and this is why I caution people greatly against ever using this, all right? What you're effectively saying is, I, who you've entrusted to sit on this board, am incapable to control myself and be a rational human being and make these decisions that you've entrusted me to make. I strongly caution elected officials against it. I caution appointed officials to use it. But keep in mind, it's there in a complete outlier case. So with that, that is the Sunshine Law, quasi judicial matters, the Public Records Act, and voting conflicts. Do you have any questions?
So you talked to, so I'm a developer, relationships, and let's just say that you closed a deal with somebody months ago and you find out, hey, they're coming here to work a deal.
Mm-hmm.
You're not doing business with them anymore,
right?
Should you vote or should you abstain from voting or not get involved or what?
Let's analyze it under the statute first. And I think you know where it's going to go, because the second key question I mentioned there, is this a current ongoing business relationship, right? If you can say with certain certitude that
it was a
business
one-time deal. It's
right. It's a one-time deal. You don't foresee any, you truly don't foresee anymore. It's just not, you can say with a straight face, and it's true in your own mind, it's not a current ongoing business relationship. None of the law, you're not required to abstain. Okay. And I'd probably advise, exercising judgment based on the particular decision that's being made. If it's an uncontroversial decision, right? Something not wildly contested or anything like this, I think it'd be pretty easy to just say, hey, just want everybody to know I had this, but it's not a voting conflict, but I just wanted it out there. If it's super close, or, super contentious, again, it comes down to how it really is. I'm not going to tell you to not vote unless you feel that you would be, sending a bad message with or what have you, because it is that option to not vote in the instance where there is a potential one, that is an option for you to exercise. It's not a requirement that you abstain when there is a potential conflict of interest. Your only obligation is to abstain when there is, when it checks every single box under this statute. So again, it could be easy or it could be hard based on the politics of the particular situation, but you are not required to on the facts you just gave me. Any other questions? All right, well, thank you all.
Thank you.
Thank you.
Absolutely. I hope it's been helpful.
Yeah,
Thank you.
thank you all.
Okay, we're all good? Ready to go home?
On your agenda.
Ready to go home? Let's go home.
Oh, good.
Thank you, guys.
Okay,
See you, Jay.
okay.
Okay, see you later, man.
Well, good to see you.
Thank you all.
Thank you. Thank you very much.
Okay. Good job.